Hi everyone, welcome to our webinar on terminating employees, the best practice for avoiding personal grievances. My name is Ruby and I'm an associate in Legal Vision's employment team, and I'm joined today by my colleague Jess, who is a senior associate in our disputes team. So before we begin, just a couple of quick housekeeping items. You'll receive a recording of the slides in your email after the webinar, so no need to take too many notes. Please also submit questions in the chat box, and we will try to get to all of these at the end of the webinar. And lastly, please, can you complete the feedback survey after the webinar? Your feedback's really appreciated. So also, I guess another point to note is that all attendees are eligible to receive a free consultation with us to discuss how we can help you with your contracts or any of your legal needs. So to request your free consultation, provide us with your contact details in the survey that appears at the end of the webinar. So today we will be discussing types of personal grievances and examples of them, and then how to avoid or mitigate them, how to manage a personal grievance claim, and its discussion around remedies and costs. So at the end of the webinar, we will be answering some of your questions, as I said, so please submit these along the way. Jess will now begin speaking about personal grievances and what they are.
Thank you, Ruby. Now, a personal grievance is basically a complaint raised by an employee about their employer. Employers tend to fear the term personal grievance. They may even consider it the same as going to court. At the end of the day, the point of a personal grievance is to make the employer aware that there is an issue. Once the grievance has been raised, the parties take steps to resolve the issue. Now, there is a time limit for an employee to raise a personal grievance, being 90 days, except if the personal grievance is for sexual harassment, where the time frame is actually now 12 months. Now, I'll briefly run through a few of the more common personal grievances as defined in the Employment Relations Act 2000. The first and most common personal grievance is for unjustifiable dismissal. This is when an employee believes they have been fired or made redundant without any good reason or by way of a fair process. The next personal grievance you may have heard of is constructive dismissal. A constructive dismissal is when an employee feels they have been given no choice but to resign. Unlike the personal grievance states, it actually starts when an employee resigns, and the burden of proof is on the employee to prove that their employment was so untenable they had to resign. A constructive dismissal does not need to be the result of a single event. It may actually be a result of a series of actions or inactions by the employer. The third personal grievance I have listed is also very commonly raised, known as unjustified disadvantage. Basically, an employer must not take any action that is unfair or disadvantages employees. I'm going to give a few examples just to illustrate when an employee may have grounds for an unjustified disadvantage claim. They are when an employer does not deal with an issue that has been raised by the employee, and that makes it harder for the employee to do their job properly. For example, bullying, harassment, health and safety issues, or inappropriate behaviour. Another example is when an employer withdraws work or does not give work to an employee, or when an employer demotes the employee into a lower job, or when an employer changes the employee's hours of work or pay without consultation. Another common example is when an employer does not give an employee an opportunity to respond to allegations against them, or if an employer does not provide a safe workplace. The fourth personal grievance I have listed is discrimination, sexual or racial harassment. As the audience would know, an employer must not single out staff for differing treatment for unlawful reasons. It's okay to treat staff differently in some cases, for example, handing out bonuses for good performance, but treating staff differently because of race, sex, religion, or age, for example, is not okay. Sexual harassment covers requesting sexual favours from staff in exchange for special treatment, and it also includes exposing staff to sexual material or behaviour they might find offensive. The last personal grievance I will talk about is duress in relation to membership of a union. Employers are not allowed to pressure staff in relation to union membership. That includes pressuring them to not join a union at all or to join a particular union. As you will see, the personal grievances under the Employment Relations Act are very wide, but the categories highlight various types of behaviour that is not tolerable in the employment relationship. I will now hand over to Ruby to discuss the employer's obligations.
Thanks, Jess. So I'm sure you've heard the term before, but acting in good faith and following fair processes do go a really long way to help mitigate the risk of a personal grievance claim. So in terms of good faith, it's really important that all employers always act honestly, openly, and without hidden motives with employees. It's really important to raise any issues in a fair and timely manner with employees and remaining positive and providing a positive workplace. In terms of a fair process, it will depend on the circumstances surrounding the particular employee and whether you followed the relevant provisions in their employment agreement and in your workplace policies. So a common reason for termination is often misconduct. So if an employer is terminating an employee for misconduct, it's really important to firstly seek advice. We always recommend coming to us to have a chat before you consider doing anything. But ideally, the process is always investigating the matter relating to the employee, raising your concerns with the employee in a meeting, allowing the employee to respond to your concerns, and really genuinely considering the employee's response before making any decision around misconduct. That's just an example of one process to follow. There are other processes, and as I said, it will depend on the circumstances. So we recommend getting advice before carrying out any process. And Jess will now look a bit more in depth at the formal grievance procedure and the steps to follow.
Thank you, Ruby. And now I'll briefly run through the personal grievance process and how the parties can resolve an employment relationship problem. The first action is when the employee raises the personal grievance with the employer. That can be verbal, email, text, or letter. It would generally describe the facts and details giving rise to the grievance and require a response from the employer and request an opportunity to resolve the personal grievance. There has to be enough detail provided in the personal grievance for the employer to be able to sufficiently respond to the grievance, to know exactly what it's about. After an employee raises a personal grievance, we recommend you respond to the personal grievance in writing. Ideally, the parties are able to resolve the personal grievance informally without the need to head to mediation. If the parties do resolve the personal grievance informally, the parties would enter into a record of settlement, which is a formal document setting out the agreed settlement terms, which is then filed with the Ministry of Business, Innovation and Employment and certified by a mediator. If the parties are unable to resolve the personal grievance informally, normally the employee will request the employer's attendance at mediation. Attendance at mediation is voluntary for both parties, which is important to be aware of. Essentially, mediation is an out-of-court negotiation in the presence of a mediator where the parties attempt to resolve the dispute without the need for a formal hearing. If the parties attend mediation and are unable to resolve the personal grievance, the employee may proceed to the Employment Relations Authority and file a statement of problem. This is a formal document setting out their claim. The employer will then have an opportunity to respond to the statement of problem, and the matter will be timetabled for each party to provide evidence or statements and listed for hearing. If the matter does proceed to a hearing, a member of the Employment Relations Authority will decide the matter on the facts and make what's called a determination. Determinations are public documents, and it is important to be aware of that because they are freely accessible online unless a non-publication order has been granted. If a party disagrees with the Employment Relations Authority determination, the party has 28 days to appeal the determination and the matter will be referred to the Employment Court. If a party fails to comply with the determination, the other party can apply for a certificate of determination from the Employment Relations Authority, which they can then file in the District Court for enforcement. It is important to note that at any stage of this process, parties are able to continue negotiations and enter into a record of settlement, which can be filed with the Ministry of Business, Innovation and Employment. I will now hand over to Ruby to give some tips on managing a personal grievance.
Thanks, Jess. Yeah, so as I'm sure you're aware, receiving a personal grievance is a very stressful time for both employers and employees. It's really important not to respond with any knee-jerk reactions. So as set out on the slide, it's really important to seek advice immediately. Employers will have 14 days to respond to a personal grievance. So with your lawyer, you'll meet with them and you can discuss the weaknesses and strengths generally of the claim from the personal grievance from the employee. And from there, a strategy can be agreed. So after a strategy is developed, there will usually be some sort of negotiation, as Jess has mentioned, depending on the circumstances of each case. It will depend on what strategy is taken. So generally, say you accept the employee's grievance, sometimes offering to reinstate the employee is a really good solution, wherever practicable, but sometimes that's just not possible. The employment relationship may be too strained. So another option would be reimbursement for lost wages or compensation for hurt and humiliation. These are options to consider and they should be discussed with your lawyer. We can always help with strategy if at any time a personal grievance is raised. Otherwise, if you deny the personal grievance, so you don't agree with what's been raised and you disagree with the background or any of the claim, usually you'll set this out in some sort of response letter. And from there, once that response letter has been sent, the employee may send another letter. They may continue to press their case, or as Jess mentioned, they may invite you to attend mediation. So sometimes employers want to ignore or deny the personal grievance. The best case scenario, if this was to happen, was that the employee drops the claim and you don't hear from them again. At the worst, they will lodge a statement of problem with the ERA. And it's likely the matter would be reverted to mediation as well. And mediation is generally the most common option if the employees and employers can't settle. So the Employment Relations Act does emphasise mediation. As Jess mentioned, it is a great way for employers and employees to discuss issues and resolve grievances. Gives you an opportunity to present and discuss both sides of the story. And you don't need a lawyer to attend mediation, but either party can take a representative, and it can be beneficial for both to have someone there putting their case forward for them. And just as a general note, 90% of personal grievance are sorted through mediation before they get to the Employment Relations Authority or Employment Court, but as we'll discuss in some cases a bit later on, it can get to that point. Jess will now have a chat around personal grievances and the remedies and costs that may come with those.
Thank you, Ruby. I'll now just briefly go through the remedies and costs associated with a personal grievance. So the first remedy I will discuss is reinstatement. This is when an employee is reinstated into their former position or a position where they are no less disadvantaged. Where reinstatement is claimed, we find it is often done for strategic reasons to increase settlement amounts. We're seeing reinstatement ordered by the Employment Relations Authority less frequently at the moment. I'd say that's a result of long waits for when a matter is filed. Perhaps it takes 9 to 10 months before you get a hearing date. That makes looking for alternative employment and moving on with your life as an employee more attractive. The second remedy is reimbursement for lost wages. Now, a claim for lost wages is to compensate the employee for wages they would have reasonably expected to receive had they not been dismissed or disadvantaged. The Employment Relations Authority may order an employer to reimburse the employee for lost wages. This can be up to a maximum of 3 months ordinary time wages, although the Employment Relations Authority does have discretion to award more, which some people aren't aware of. This may be suitable where the circumstances associated with the termination or unjustified disadvantage was so grave that the employer was unable to find alternative employment within a 3-month period. In saying that, an employee does have an obligation to mitigate their loss. That means they can't just sit at home and wait for the hearing, and they will need to establish that they've actively searched for work if they hope to receive that compensation. The third remedy I will discuss is compensation for hurt, humiliation, loss of dignity, and injury to feelings. Now, the quantum of this remedy is entirely based on the harm experienced by the employee as a result of the termination or the disadvantage. The Employment Relations Authority takes a banded approach to assessing this compensation. So the bands are $0 to $10,000 for low harm, $10,000 to $40,000 for medium harm, and $40,000 plus for high harm. Awards above $30,000 are very rare, and the average award for an unjustified dismissal appears to be around $15,000 to $20,000. Again, there does need to be evidence to establish the harm, so this does need to be proved by an employee. And it's also important that employers are aware that compensation for hurt and humiliation is tax-free. So it is quite a carrot for most employees in that regard. A less common remedy that we see is compensation for loss of benefit. So it is good to be aware of this one. This does not include wages, but includes things like KiwiSaver contributions, maybe access to a company vehicle or lost access to health insurance, bonuses and commissions. Remedies can be reduced by contributing behaviour by an employee. The amount reduced varies, but is very common. It's commonly known that 30% is a high amount for contributory behaviour. Sometimes representatives will claim that an employee's behaviour was so bad that it would contribute to 100% reduction, but this would be very unlikely to be awarded. There is then the legal costs to defend a personal grievance claim, and obviously the employer is incurring legal costs as well. So, generally that's something to be aware of when the parties are thinking about settlement arrangements. I will now turn back to Ruby to discuss some interesting cases.
Thanks, Jess. So I guess the purpose of showing cases is just an example of, what we've talked about today. Obviously, a personal grievance has been raised and it's gone past the negotiation point, and obviously the employer and the employee have ended up in either the authority or the court. So the first case I will discuss is AJY and Chief Executive of the Department of Corrections. So in this case, an employee was found to have been unjustifiably disadvantaged and unjustifiably dismissed, so 2 personal grievances, in circumstances where the employer failed to respond to a bullying complaint made by the employee. So the employee was awarded a substantial sum, in this case, $40,000 for compensation for the hurt, humiliation, loss of dignity and injury to feelings that Jess just spoke about. This is a significant amount, and I guess the importance of this case, it really highlights how investigating employee claims, or particularly bullying complaints, or anything that comes to you as an employer, is really important. As I've touched on, your lawyer can assist from the very get-go. If you do receive a complaint, they can assist in how to investigate to make sure that you do respond. And we always suggest coming to us as soon as possible, or your lawyer, before carrying out a process to make sure you get it right. So in this case, if the employer had investigated properly, it's likely that that figure would not have been so high. But it's just an example of an investigation not being followed properly. The next one is Mulqueen and the Merino story. So the issue here was whether the employee was unjustifiably dismissed based on a finding of serious misconduct. This was following a customer complaint. So this went to the authority first and then the employment court. So I'll just touch on what the authority found. So that's the Employment Relations Authority. The authority found that the employer didn't follow a fair and reasonable process, and that its decision to dismiss the employee was not fair and reasonable in all of the circumstances. So just to touch on the reasons they found, that was the employer's investigation into the customer complaint was insufficient. So that's that first point I've talked about today, is the investigation is really important. The court held there that the employer should have spoken to the customer that made the complaint to verify the employee's account as well. The employer didn't follow the summary dismissal procedure that was set out in the employee's employment agreement because it failed to meet with the employee, failed to disclose historical customer concerns, which resulted in the employee being unable to consider and comment on them. The employee did not have an adverse employment record, so that was looking into the relevant previous conduct. And the authority concluded that the employee had a personal grievance for unjustified dismissal in this case. As Jess had touched on, there is the element of contribution. So the court did find that the employee did contribute, so the award was reduced for that contribution. And the employee was awarded 3 months remuneration in this case and $10,800 in compensation after a 10% reduction for contribution. So this case, as I said, highlights the importance of getting the process right from the outset, making sure that you investigate fairly. Sometimes it can seem very clear cut that it's misconduct, but you still need to investigate. You need to consider the employee's response before making any decision. And again, if you've got procedures in your employment agreements, it's really important to check these first and make sure you are following those before you carry out a process. And then the last case is an employment court case, and this one highlights how following a fair process and investigating properly can mean a claim is eventually dismissed. So in this case, the employee resigned with Waste Management because there was an investigation held and she was dissatisfied with that investigation. The investigation was around an inquiry over GPS data obtained from her company car. So she claimed, the employee claimed, that the investigation forced her to resign in the circumstances that made the resignation an unjustified dismissal. So the Employment Relations Authority, this is where it went first, agreed, and they awarded her $20,000 hurt and humiliation and reimbursement of just over $11,000 for her lost wages. Waste Management then challenged the determinations and sought a full rehearing for both, and the company's case was that Miss Jones did resign and was not dismissed. So Waste Management did, ultimately the court found that Waste Management did not engage in a course of conduct with the purpose of causing resignation. So the court held the investigation was appropriate and that the company did not breach any duties to cause a loss of trust and confidence, nor any disparity of treatment that made her resign and made the resignation foreseeable. So ultimately they held she was not constructively dismissed. So as I've highlighted, this just shows how following a fair process and acting in good faith is really crucial in defending a claim, particularly if it goes as far as the employment court. So we'll now turn to some of the questions that we've got. Jess, do you just want to run through some common questions we may get?
Yeah, so some common questions we come across in relation to personal grievance claims are, can an employee raise a personal grievance outside the 90-day timeframe? Now, an employee may raise a personal grievance outside the notice period if the employer agrees. If the employer does not agree, the employer may be able to raise a personal grievance, but it would come down to a determination by the Employment Relations Authority, and that's based on whether the delay was due to exceptional circumstances. It is important to note that an employee has 3 years to begin proceedings in the Employment Relations Authority after it has first been raised with the employer. The second question we commonly come across is, can an employee raise a personal grievance for unjustified dismissal in a trial period? The answer is no. And the third question, which is a little bit more of a fun fact because most people haven't had to file in the Employment Relations Authority, but is how much does it cost to file a statement of problem? And it's $71.55.
Cool. Thank you, Jess. We'll now just turn to some statistics. So I guess this just highlights the amount of settlement applications that were received per year since 2013. So if you can see those numbers on the screen, noting that there is a significant increase in 2020. This is likely due to COVID. We received, a lot of personal grievance claims, particularly around redundancies and processes and things like that. So it's important to follow a fair process so you can avoid being one of these statistics. So we hope you found the webinar informative. You might also find our free publication, How to Inspire, helpful. You can download it from the handout panel or by scanning the QR code. We also have an upcoming event that may be of interest to you. It's on Deal Structures 101, and this is Understanding Equity, Safes and Convertible Notes, and this will be held on the 29th of November at 12 p.m. You can register on the website link contained on the slide. So we're going to answer your questions shortly. So while you submit them, we'll just take a minute to tell you about our membership. So Legal Vision's membership is a cost-effective alternative to the expensive hourly rates you experience with other law firms. For an affordable monthly fee, you receive cost certainty and all-inclusive legal services. So this includes unlimited document review, drafting, amending, reviewing business contracts and commercial leases. It includes unlimited advice consultations with our team of over 100 specialist lawyers, including business structuring, employment, disputes, and more, and unlimited domestic trademark registration. So as a Legal Vision member, you won't worry about the cost of lawyers ever again, so you can think of it as having your own in-house counsel. We'll take care of all the business as usual legal work, so you can focus on running your business. And if you are in-house counsel, our membership is a cost-effective solution for outsourcing additional legal work. So to learn more about the membership and how it can help you, you can request a free consultation when the survey appears at the end of this webinar. And now we'll turn to some of your questions. So the first question we have that came through is whether an employer can terminate the employment contract while the employee is on sick leave.
So I'll answer that one. Yeah, so basically I think I ran through what the definition was of an unjustified dismissal, but there's two things to think about, and it's whether the termination has been done by a fair process and whether there's a good reason. So generally these types of questions are very fact specific. So I'm not sure obviously if this employee they've had a warning or whether you're terminating under clause in the agreement for medical incapacity. It's hard to kind of know just from the broad questions, but generally you can't just blanket terminate someone because they're on sick leave. It comes down to the facts. But just keep in mind, if you are thinking about terminating an employee, they could raise a personal grievance if you haven't followed a fair process and there isn't a good reason. It's not a good reason to just terminate someone because they haven't turned up to work because they've got a medical certificate. So it's always important to look at your agreement in the first instance. You might have a clause in there setting out what to do when an employee is on sick leave. Generally, there's a clause in there referring to providing a medical certificate. And the other one is whether you can terminate for medical incapacity. Generally, we don't recommend doing that off the bat because it can get quite complicated. But obviously, it's one of those things where it is quite fact specific. But it's not a blanket no, but it has to be a fair process and good reason. So that's my answer to that question.
Thanks, Jess. We have another one. Personal grievances and claims of unjustified dismissal, the same thing?
So no, as discussed this morning, there's a personal grievance is the general overbroad term, but then under that there's different sorts of personal grievances, and one of those being unjustified dismissal. Thanks, Ruby.
Thanks, Jess. Which type of employees can raise a personal grievance?
Anybody who's got an employment agreement can raise a personal grievance. So yeah, obviously that includes casual employees. It obviously just excludes independent contractors, really. That's where that ends up.
Yeah, thanks, Jess. Just have a look at what other questions we have coming through. So this is one that might be a little bit specific, but we can give it a go. So how long does an employee have to file the statement of problem after raising the personal grievance with the employer? I think you've touched on that, Jess, around the 3-year point.
Yes, yeah. So they do have 3 years. So once they've filed it, obviously it would be very unlikely that it would get to 3 years because obviously, the parties want to move on. But hopefully the parties would resolve it. It would be unlikely that it would remain dormant for that amount of period of time. But there is the 3-year time limit to bring it But obviously, yeah, they've got the 90 days to raise the personal grievance, and then once, if that parties haven't resolved it, they can proceed to filing a statement of problem.
So that question also had some questions around estimated cost to prepare statements of problems and to attend mediation for settlement. It's much easier for us to give you any kind of fee estimate after a consultation, because we need to understand a bit more around what's been raised before we can give any fee estimates. So if that is a question, please book in a consult and we can happily provide any kind of estimate for you with a bit more detail. We have another question. So this one was, can you run through the general step-by-step process when going through a PG process? So how do you invite the other party to a meeting and how do you present your findings? Did you want to answer that one, Jess? Or
yeah. So I kind of went through the step-by-step process, but it all depends on whether the employee has a legal representative or not, generally. If there is a legal representative, it's they'll probably engage you much quicker, or the employer. If they don't have an employee, you can obviously invite the other party to a meeting at any time to discuss it. They've obviously raised the personal grievance, so it's acting in good faith, which is always the employer's obligation. Would be to invite them to a meeting if you think it's something that you could resolve informally. You can present your findings verbally. You can, but if you did present them verbally, it's always good to back them up in a written form. So hopefully that answers that question.
Yeah, sounds good. And as Jess mentioned, it's always helpful to, if you do have a lawyer, the generally will be a process that can go through in terms of negotiating. There is quite a few options in terms of responding to a personal grievance, so recommend definitely speaking to a lawyer if you do receive one, just to make sure that you have all options available to you. Okay, I think that's all the questions we have received today. Of course, if you have another question, please book in a consultation. We'll be happy to answer. Make sure you please fill out the survey that will pop up, and of course your contact details for the complimentary legal consultation. Thank you so much for joining us on the webinar today.